Hi, we're back again, and introduce yourself again.
I'm Easy Harris, a community activist and a disabled American veteran here in Orlando, Florida.
And I'm Erwin Eisenstein, and I'll be on camera in a little bit. They call me Ironstone, and I've been active in lots of different areas, and I guess what I wanted to go over, and I have this script and this script. We can just go over some of these cases because they don't apply apparently in Florida. And it shocks me because, usually you give judges judicial notice of a higher authority and they're supposed to follow it. Now, I'm not a lawyer, but I have an education that allows me to read and understand. Now, maybe you want to read the cases and the explanation, I'll expand on it.
You want me to start with Butterworth
Yeah.
versus Smith, related to the rights of a person to report on his experience from a grand jury hearing, finding that the Florida law infringed on the First Amendment.
Right. What that was about is a reporter was called to testify in front of the grand jury. And Florida law at that point said that you couldn't talk about anything that went on before a grand jury. And it didn't have a restriction for a particular time, place, or manner. And the reason that's important is if the case is over and you're not going to harm anyone else, why shouldn't you be able to talk about it? Now, Butterworth was the Attorney General of Florida. This reporter, Smith, actually took a case to the federal district court, and the federal district court dismissed the case. So he appealed it, and the federal appellate court, which I believe is the 11th Circuit, said, you can't tell him he can't write about his own experiences. So Butterworth, the Attorney General of Florida, appealed it to the U.S. Supreme Court, who once again slapped his hands and said, you must be out of your mind. The First Amendment is there so that people can be critical of government.
Right.
In my cases, in Florida, what I find is the Florida Supreme Court is censoring. They're holding some of my records confidential, in violation, I believe, of the Supreme Court of the United States. And someplace later, I actually submitted a writ of cert. That means I petitioned the United States Supreme Court to hear the case. It was denied cert. And what that means is Florida can continue to violate people's rights, even though it's contrary to, not one, but many Supreme Court rulings. And the chances of a non-attorney getting a case before the Supreme Court is probably about 1 in 10,000. It's 0.0001. And what it means is you have lots of people who assert their rights, and if you don't have the money to take it into federal court, or you take it to the highest court in the state, in this case the Florida Supreme Court, and they say, no, we don't agree with you, you're stuck. So you have to start over again in a federal district court. I don't know. And we have an attorney general here in Florida who doesn't want to protect individuals' rights. And that's what it amounts to. Okay, the next case.
Her name is Pam Bondi.
Right.
Attorney General.
Yes, that's true. And it's funny because I'm I've been very critical of judges because I've seen enough bad judges to say, why are they still on the bench? Although I've also been before several good judges. And I sometimes say, why are they still on the bench? Okay, you want to read the second one and read the whole thing.
Berger versus the U.S. That's the Supreme Court, the duties of a prosecutor to search for the truth. Many prosecutors fail to heed the advice of the United States Supreme Court when the court clarified a prosecutor's function. As such, the role of a prosecutor is to see that justice is done. Berger versus United States, 295 U.S. 7888, 1935. It is as much as a prosecutor's duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one.
Okay. Now, I'm sure we can probably talk about that for about an hour. Let me ask you some questions. And again, I really can't say I've been involved with Mr. Harris's case for any length of time. This is really only the second time we've met, and the first time we produced a video. And we've spoken on the phone, and the reason we've done that is some of the things that he tells me are outrageous. And, I'm sometimes questioning if, Florida follows the United States Constitution, or whether they effectively have taken Easy off the streets and done it basically because he was politically active, and to prevent him from winning a seat on the Orlando Council, and possibly because he would expose some of the, quote, corruption and government deals that aren't necessarily best for the majority of people in Orlando. Now, you were telling me about your bail.
Yes, I was arrested the first time, and this was the first time in my life that I've ever been arrested. It was November 12th, 2009, at the age of 50. I was arrested on a couple of charges to do with selling drugs. And my bond was $100,000. So I bonded out the next day. That was November 13th, 2009.
How did you bond out?
Actually, when I was in court, I went to bail bond school, so they knew about the arrest, and the people who owned the bail bonds company, actually, the mother who actually owned the company, because I went to school with her son, she was there in court, and so we made the arrangements very quickly, so I was able to bond out within 24 hours of the first arrest.
Okay, let me ask you something there. You're running for an election in Orlando. Mm-hmm. Did anyone ever consider you a flight risk?
No. I had never been arrested before. And in fact, to tell you how this all came about, when I was arrested on November 12th, I had 26 agents from the MBI.
What is the MBI?
Metropolitan Bureau of Investigation. It is the law enforcement arm of the state attorney's office. See, here in the 9th Judicial Circuit here, the state attorney has his own police officers. And that is quite unusual. It seems like they supersede any other law enforcement. But that particular night, I had a newspaper reporter in my office. My door was unlocked. And they proceeded to open up the door, and they threw in an explosive device, and then simultaneously they broke out the front 3 windows. My door was open. They didn't have to do any of that. And by breaking out all the windows and throwing in the explosive device, it's supposed to have been the element of surprise. But from that particular thing there, I was able to really learn what was really going on and how they operated. Really, to make a long story short, I did bond out, and after I was taken down to the police station and then to the jail, they failed to secure my office. So here I have thousands of dollars worth of merchandise and office supplies and computers and stuff that were stolen, and even evidence that I had to show that that I could counteract their charges. Even that was stolen.
And the police did nothing. They didn't secure your
No,
office.
and let me tell you, within 2 hours of being arrested, while I'm in jail, someone is using my credit card. And
Did the police take the credit card?
well, they took my wallet and they only gave me back my ID. And so they had in possession not only my cell phone, my keys to my office, and my wallet, which I never, until this day, I have not gotten back. The second arrest.
Let me just go into this a little more, and you can probably face the camera a little. Something disturbs me. Was there a complaint made against the police?
In terms of my...
Of them taking your wallet, not returning it, how your credit card was basically taken from your wallet while it was in the possession of the police?
Believe it or not, I had to file a complaint with the Internal Affairs. My court-appointed attorneys would not do it. And so, while I am, just really basically at their mercy, because if you don't pay for attorney, you don't get that performance of service really from these court-appointed attorneys. You may make suggestions to them because you're not paying for it. They don't have to follow it. But that was basic common sense, that if my wallet wasn't returned to me, if my keys were not returned to me, and stuff was stolen, that she would file a complaint. So I brought up the issue of spoliation of evidence, in which they claimed they hadn't heard of that. And so that's basically...
These are your attorneys?
Right.
Those that have been
Right.
appointed
Right.
by the court?
Right.
Okay.
And what I did was I made sure that I put that in writing. There were several letters that went out to all the attorneys, because I had 3 at one time working on the case, really basically starting off after the second arrest, had about 8 attorneys. But when they consolidated my charges down to 3 attorneys, I made sure that I informed them in writing. And it's very important, folks, that if you have court-appointed attorneys, whatever you're requesting, put it in writing, and so that you can cover yourself. And that proved very worthwhile for me later down the line. But I told them about the stuff that was stolen,
Okay.
but you can't, they pick and choose the issues.
Okay, let me ask you this. Has any of your attorneys ever done an investigation related to the police officers who were involved in breaking into your office, failing to secure it, losing credit cards in some way or another? Because usually there's a pattern that's followed. And recently I was reading, I think, either the American Bar Association newsletter, and what they have been doing in certain cities around the country is tracking the activities of police officers.
No, none of the attorneys filed a complaint. I had to do that.
No, but I mean, the idea is that when you have a police officer who acts inappropriately in one situation, it's very likely that the police officer has acted improperly in other situations. And what the ABA is doing is tracking different police departments in different cities, and found that very frequently officers have screwed up, have lied, and have basically done what is against the law, and no one does anything about it. And I'm not saying that this is all police officers, but your action was politically motivated.
There's no doubt it was. And remember, these police officers work for the state attorney's office. And that's what's really very alarming about this, because where the job of the state attorney's office or prosecutor is to seek the truth.
Well, you have it there,
Right.
but that doesn't happen.
Right.
They don't follow.
That wasn't the case, because remember, they were the ones that started the investigation. It was called Operation Easy. They said they launched this investigation in July of 2009. I was arrested several months later. But getting back to filing that report, none of the attorneys did that. I did it, and not only did I do it, but I filed a complaint with the United States Department of Justice. I got a letter back from them in 2012 stating that what I had informed them of, it appeared that there was a practice and pattern of official misconduct. They call it non-criminal charges that could be brought against them. And the long and short of it was...
Well, I'm going to break in just for a moment. There's something on the law that basically is enforced in almost every state. And I'm going to point a little bit. Am I on camera? I can't tell. It's called official misconduct. And official misconduct is if someone in an official capacity, could be a police officer, could be a prosecutor, because in some capacities prosecutors don't have absolute immunity. They have qualified immunity, and there's a way that they can be brought up on charges according to the United States Supreme Court. And one of the cases here, we'll go into that because it sounds very similar. And okay, I just wanted to put these little things in.
And, you know, today is January 31st. My case is in its 7th year.
And how much do you think this has cost the state of Florida?
Well, I can tell they probably haven't spent as much as they should have, but I've been through at least 12 attorneys. A number of them had to withdraw for conflict of interest. I'm on my 3rd judge. And it's important to know that the first judge I had was C. Jeffrey Arnold. And I want to tell this story because I filed a Florida Judicial Qualifications Committee complaint against him. And before that was, even before they responded to that, he was already off my case. And what happened was, in February of 2009, February 2012, there was a defendant named Jesse Davis. The police, the prosecutor's office, asked the judge not to allow this guy to go out on bond. He had assaulted someone, and they said that if you let this guy out, he may kill someone. The judge said he didn't care. So he let this guy out, and he gave him 3 stipulations. You have to see your probation officer, you have to take your medication, and you have to go to your psych, see your doctor. Within 45 days of allowing this guy out, he kills 2 teenagers in Winter Park and set their bodies on fire on Caddy Trail. The chief judge, Belvin Perry, moved this judge out of the circuit so fast that
That's the chief judge of the 9th Circuit
Right.
here in Orlando.
Right. At that time, it was Belvin Perry Jr. He moved Judge C. Jeffrey Arnold so fast that I didn't know that. And he moved him from criminal court to family court, from Orange County to Osceola County. And the judge retired 2 years ago. So that brought in another judge. And that judge came out of the state attorney's office, Wayne C. Wooten, that was appointed by Governor Rick Scott. And as soon as I found out who the judge was, I immediately said, it's a conflict of interest. He came out of the prosecutor's office, and my case has been in the prosecutor's office while he's been in there. And
I have to say, I'm going to break in, and I'm sorry. Do you know which governor in the United States has taken the Fifth Amendment more times than
Yeah.
anyone else?
Yeah. 75 times.
Oh, I didn't know. I thought it was only 50.
No, that's Governor Rick Scott.
Okay, and he did it when the United States, I guess, was investigating a hospital organization
HCA.
that appeared to cook their books.
Oh, no, not only that, but what they did was they stole tens of billions of dollars from taxpayers by the overbilling with the Medicaid. And he was at the head. And so, he pleaded the fifth 75 times, and they allowed him to leave the HCA as their head. And
That's Hospital Corporation of America.
And he took with him, or they gave him a severance package of over $300 million.
He was a lawyer, wasn't he?
Yes, but they paid a $2 billion fine. But when you know the history of HCA, you have to understand who were the people behind it. There were a number of senators that were involved with that. So Rick Scott could not have his connections unless he had a political connection. And so it's all corrupt. But the long and short of it was, he pled 75 times and was still able to become governor of Florida. Only because he was running against Bill McCollum. But the thing that hurt Bill McCollum was the early voting and the absentee ballots and stuff like that. And when they found out about how crooked the Rick Scott was, it was too late because people had already
voted.
And they remembered Bill McCollum from wanting to impeach Bill Clinton. And so he was not a favorite, and he lost. But
okay, let's return
But getting back to the second judge, I filed a complaint. In fact, I delivered the letter to his JA, a packet.
That's a judicial assistant.
It was August 28th, 2012. I said, listen, I have to have judicial recusal here because you just came out. And what I did was I made sure that was filed in my court docket. My succeeding attorneys, I asked them to file a motion to have him recuse himself. None of them did.
Okay, do you know why?
Well, I couldn't make them.
Okay, well, here's one of the reasons. If any attorney in Florida makes a complaint about a judge, that attorney is subject to a witch hunt by the Florida bar and also the Florida judiciary. He'll never be able to represent clients in that courthouse again. So if you say, why don't attorneys do what they should? Because they have student debts that are $200,000-$300,000 at times, and the only way that they can pay them off is if they can work successfully as an attorney.
That's true. But I finally got him to recuse himself. I had to do it pro se after going through, at that time, about 10, 11 different attorneys. And so it took me nearly 3 years. After he sent me to jail for 75 days because basically I refused to take a plea deal. And
okay, let me
right.
also break in a little bit. Mm-hmm. Okay, the attorney that you had, and if there's any lawyer out there who might consider a malpractice case, you can always contact Ezell. What happened was Ezell didn't want to take a plea bargain. And the reason, there are many different reasons.
Well, we can tell them what the plea bargain included: 2 years of community control, no prison time, and 20 years of probation. Well, I said from day one that I would never plead to it, and they thought that was a deal. And now remember, this is nearly this is more than 5 years after the case. And so I said no. And when I said no, the attorney got mad. And when I asked him if I could attend a doctor appointment instead of coming to court, he gave me authorization to go to my doctor's appointment. And so he showed up to court while I was at the doctor. So he basically told the judge he didn't know where I was or that I wasn't coming to court. And the judge put out a capias against me.
The capias is?
A bench warrant. And so I came to court the next business day, which was the court appearance on December 12th. I came to court on December 15th, and they allowed my court-appointed attorney to withdraw, and they arrested me from failure to appear. My case is more than 5 years old at the time. I had not missed any court dates. I was no flight risk. In fact, my bond had expired because the case was 5 years old. And so what he does was, he put me in jail, and he set me to have a competency hearing. But the competency hearing was 2 months,
further along.
So I had to be in jail for 60 days. And both competency hearings were done, and I've had 4 of them. And there was never an issue with my competency, but I believe the attorney, the last attorney I had, was using that as a delay tactic. And so there was nothing wrong with me, and they knew that.
Well,
but they wanted to punish me, 75 days in jail.
Let me explain something.
Mm-hmm.
What judges do is try to get someone to act on their own or pro se without an attorney.
Mm-hmm.
And what that is learning a foreign language where you don't know the rules,
No.
where you don't know the language immediately. And I would almost always tell people, if you can, don't appear pro se if the state can assign you a lawyer. But that lawyer has to be competent, knowledgeable, and willing to fight for you as an advocate. That doesn't usually happen.
No, remember, my case involved high-profile people in the government. You're talking about a city commissioner, a former police chief, and there were 2 attorneys on record that basically said they were afraid. City Hall had threatened to come after them if they represented anybody against City Hall. And one attorney said that he was very reluctant. And so when you have people that are afraid to challenge the powers that be, and they're your attorneys,
what do you do?
What do you do? And so, but do not ever compromise your principles. But what I did was I filed paperwork myself. When the attorneys would not do their jobs, I would send them a letter, and then I would file that letter in the court docket, putting them on notice that if the judge complained about anything, why the case is taking too long, why it's not progressing, the fault doesn't lie with the defendant. But they made it seem that I was being very combative with my attorneys.
The answer is, usually attorneys like to believe that they walk on water. Somehow many of them don't. They lie, they put on their pants, one leg at a time, the way the rest of us do. And I won't say their nose is brown for a particular reason, but, they have to deal with judges. And they sweet talk and do anything that they can so that they're on a judge's good terms. And I've had, I was also put in jail once. And it was a very funny thing because initially I was there in court because I wanted to see my kids more frequently. And to make a long story short, the judge lied on his contempt charge. As an example, there was an account that my ex-wife, her attorney, left out of the divorce. And she's the one who drafted it for the judge, so he doesn't want to do anything about that. One piece of paper, the account was about $15,000.
That's a lot of money.
And well, this was years ago.
Even more, where it's
Yeah.
right.
And I tried to give it to the bailiff, and it fell to the ground between us. One piece of paper. That became, let the record reflect that Mr. Eisenstein is throwing a piece of paper at the court. And I have the transcript. On the judge's sworn statement, Mr. Eisenstein took papers off the counsel table and threw them at the court. And I was charged not only by that judge with contempt, but by the Florida Board of Bar Examiners. And even after that, the Florida Supreme Court said, well, the Florida Board said this, and we agree with them, even though it was contrary to the evidence that was in the file. So I don't have much faith in the Florida Supreme Court.
If we had cameras in the courtroom,
Right.
I would have been able to. And I'm a proponent for cameras in the courtroom. I was at a murder trial and seeing the prosecutor coaching the witness, waving his hand, telling her to be quiet because she just was rambling. And, that should have been reflected when, stenographer, it can't tell you what the hand motion or coaching that the...
Okay. Why don't we end what we're talking about now, just for a little bit, and we can always come back with it because there are lots of other stories that relate. So the one lawyer lied and told the judge he didn't know where you were.
Right, but and let me tell folks that when you get a court-appointed attorney, one of the first things that you need to do, you need to check their history with the Florida Bar. You need to see if they've ever been cited, ever been suspended. And out of, let's say, the 10 or 12 attorneys that I've had, I had at least 2 that had been suspended. One for taking some money and had to repay a client's money. And I had another one that had caught a DUI charge, put on probation, but that particular lawyer failed 2 tests that showed that...
Subsequent?
Right. And was suspended for 90 days. And so
only 90 days?
And I'm getting this particular lawyer, and the lawyer never disclosed that he or she had been suspended. You have to do your history when you're getting these attorneys because this was an issue that came down that affected my defense, that when you have a attorney that's having
own problems with drug addiction or alcohol,
they're not working on your case. The judge said to me, well, how was I supposed to know? I'm not going to embarrass the attorney in front of the judge, but when it's your life that's on the line, you have to let the courts know that if your if your attorney is ineffective, let the courts know immediately and put it in your court docket what your complaint would be. So, so you get these court-appointed attorneys, these attorneys that put their names on the list because, in the downtime where they can't find clients, they want these court-appointed ones, and about 80 to 90% of them plea out. They think it's quick and easy money. But when they find out that my case is as voluminous as it is, they don't want to touch it when they see that it's a case approaching 7 years old. I can't cause a case. Just little old me can't cause a case to be 7 years old.